Hello friends. Today we are going to discuss about ethical and legal aspect of plagiarism. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at Nimans, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. If you want to have a legal opinion, please do contact an advocate. In this video, I am going to discuss about ethical and legal aspects of plagiarism from Indian perspective. As we know, law changes from country to country. In certain laws, it changes from state to state within the country. However, if you are publishing a book or a manuscript in a journal, you need to know which is the publishing company, whether it is the international publishing company or the national publishing company. What is the territorial jurisdiction? Which laws are applicable if you are publishing in that journal? And you also need to know what are the local laws applicable with regard to that company. And if the publishing company, where it is registered, under what laws they are operating. You need to know the editors and which place from they are doing this editing business. Not only that, if you're a multi-author or a multi-editorial, you need to be further safe with regard to how the law is applicable. Let's discuss about this ethical and legal issue. The first one is ethics of publication. We should never ever forget that we are standing on the shoulders of giants. If I have seen the further, it is by standing on the shoulders of giants. It is a simple word. We should never forget the past scientist. Today, I am able to understand certain science. This is because the past researcher and scientist have given me a platform. Hence, we need to credit, we need to cite those researchers. And that is our duty, not only moral duty, but also the legal duty. Let's look into the various publication ethics and let's look into the checklist. First and the foremost, before you do the research, you should get the approval from the institutional review board, that is ethics committee, and also you need to take consent from the subjects. You need to make sure that the data accuracy is there, no falsification and fabrication is done either by the researcher or any person in the research team. You have to be very careful with regard to plagiarism and also self-plagiarism. Further, when you're submitting, whether doing a submission fraud you're doing, and you need to have the ethics of authorship. Whom do you are giving credit? Further, you need to declare your conflict of interest before you publish. But however, in this video, I'm going to discuss about plagiarism. Plagiarism is presenting someone else's work or ideas as your own, with or without the consent, by incorporating it in your work without fully acknowledging them. Although, if the copyright owner has said yes, you need to quote. Although legally you may not be liable for not quoting them, but the moral obligation, you need to cite this idea is not mine. This idea is from so-and-so researcher. That needs to be quoted. All published, unpublished material, whether in manuscript, printed, economic form, should be cited. Whoever is the author, you need to give the credit. That is called as plagiarism. If you don't give the credit, that plagiarism has different shapes and forms. There are 10 different types of plagiarism. Complete plagiarism, when you copy-paste the whole thing. Source-based plagiarism, you have taken from certain source, but you have not quoted them. Direct plagiarism, that is, you have taken somebody's idea and you are putting it as your own. Self or auto-plagiarism, you have already published it, but now again you are publishing without citing the original publication. Paraphrasing plagiarism, that means you have taken somebody else's work and you have phrased in your own words. Still, you have taken that idea. You are stealing somebody else's idea. If you don't cite, it is called as paraphrasing plagiarism. Mosaic plagiarism. If you are taking ideas from multiple authors or researchers and putting it in a single paragraph or a two and telling that it is my own idea. Accidental plagiarism, that means you have got a novel idea, but unfortunately you do not know already somebody has done work in this area. That may be accidental plagiarism. Hired plagiarism. Here, you're asking somebody else to do your publication and research work, and you're not giving credit to them, that is called as hired plagiarism. Borrowed plagiarism is again considering a collaborative work done by a group of researchers and authors, and you have taken the ideas from various authors or the researchers and you're not giving any credit to them. That is borrowed plagiarism. You need to keep all these in your mind. Plagiarism can come in any shapes, any forms, and at times accidental. And you may be a researcher and you'll be shocked to know that you are done either self-plagiarism or else accidental plagiarism. Hence, you need to be very careful. Let's look into the International Committee on Publication Ethics. It is called as COPE. They have come up with various guidelines. Guidelines on good publication practice is available now. This COPE was formed in 1997. At present, 1,35 lakh members are there across 100 countries. Look at the numbers. The number is 1,35,000 members across 100 countries. There is a council. That council are basically 40 elected members. These elected members meet 4 times annually and decide about the burning issue. They come up with the guidelines. And they also do training, publication of guidelines, and also they will guide the editors with regard to publication. If you look at this, this is the COPE's mandate. First and the foremost is organizational purpose. That is, publication or a publisher, what should be the ethics? Second, showing leadership with regard to ethics in publication. Having integrity. At the same time, you need to teach integrity with regard to the researchers. Decision making and risk control is one of the important mandate of this COPE. Board effectiveness, especially if there is any kind of plagiarism, or else if any journal editorial is requesting for help to guide them. Diversity, and further openness and accountability. If you look at the COPE's mission is committed to educate and support editors, publishers, and those involved in publication ethics with the aim of moving the culture of publication towards one where a ethical practice becomes the norm and part of publishing culture. Our approach is firmly in the direction of influencing through education, resources, and support of our members alongside the fostering of professional debate in the wider community. That is the COPE, my dear friends. If you look at the COPE, how it operates, if there is a plagiarism complaint is given, and the guideline is very clear, you need to check, ask for the reviewers, what are the evidences? Look for it. Contact the authors and also mention that this issue has been raised. Look for whether the plagiarism is there or not. If there is no problem, go ahead and publish. No, if there are minor errors, you need to request the authors to cite and paraphrase so that they are in their own words, but need to give credit for the earlier publication. If there is self-plagiarism, you need to tell the authors subtly that you need to quote your own article also. Further, if the plagiarism is very clear and it's a major plagiarism is there, in such a scenario, you need to contact all the authors and also tell them we're withdrawing the manuscript because there is a fraud. That needs to be clearly told. Hence, these are the important COPE guidelines which talk about if there is a plagiarism. A letter of explanation and educating the authors where there appears to be a genuine misunderstanding of the principle need to be done. Further, the second step would be to letter of reprimand and warning as to future conduct has to be done to the authors. A formal letter to the relevant head of the institution or funding body that needs to be done if the plagiarism is a major issue in the authors. Further, if you think the plagiarism at this point of time by the authors was a major one, a publication of notice of redundant publication of plagiarism to be done. If required, editorial giving full details of the misconduct can be done in the journal. And also, a refusal to accept future submission from the individual unit, or institution responsible for the misconduct for a stated period or for the lifetime can be done by the journals. This is scope guidelines, my dear friends. Further, formal withdrawal or retraction of papers from the scientific literature, informing other editors and indexing authorities. That means the author's or the researcher's name can be blacklisted. And also, further, if you think it is worth reporting if the author has done multiple plagiarism, reporting the case to the General Medical Council or else medical licensing authorities, so that this person is removed from practice to license. That will be a severe form of punishment, my dear friends. From the Indian perspective, there are various professional bodies, especially with regard to ethics: ICMR, Indian Council of Medical Research, DBT, and UGC. Further, in India, we have a Copyright Act of 1957. Let's discuss each one of them. First and the foremost, Indian Council of Medical Research 2017 ethics guidelines have been published. What do they talk about plagiarism? What about the misconduct? How they are represented in this 2017 ethics guidelines? In 3.6, research misconduct and policies for handling misconduct has been clearly spelled out. It says institutions should develop policies to address scientific and research misconduct. That has been clearly spelled. But however, that has not been clearly said what mechanism institution should do. That was with regard to 2017 ICMR ethical guidelines. But further, they also specified and also defined about plagiarism. Plagiarism is wrongful appropriation and stealing of publication or publication of another paper or another author's from other language, thoughts, ideas, or expression, and the representation of them as one's own original work or duplicating one's own publication. That is self-plagiarism. That's what the ICMR has said. But there was no institutional mechanism how it should be done. How should be the procedure? What should be the punishment was not defined. Hence, the Research Integrity and Publication Ethics of 2019. Let's go through this policy. This policy is applicable to all ICMR scientific, technical staff, students, regular and contractual, involved in research at ICMR headquarters or at ICMR research institutions, network, centers, or if you have received ICMR grants or field units across the country, irrespective of source of fundings. That means if you are related somewhere or other with ICMR, this policy will be applicable. There are mechanisms have been advocated in this policy. One is Research Integrity Unit, which will be situated in ICMR headquarters at New Delhi. And this will facilitate and guide the researcher with regard to integrity, and also if there is any kind of plagiarism or research misconduct, that will be investigated. Further, there will be a ICMR Bioethics Unit. This is the Bioethics Unit which will be updating the policy on research integrity, misconduct, and publication ethics. Further, there will be a Research Integrity Officer. The director of ICMR will designate one senior scientist as a Research Integrity Officer to facilitate the implementation of the policy. Let's look into the process, how the complaint is given, and how the procedure of complaint will be investigated. If there is a complaint either to the director or to the head of the ICMR, these complaints can be anonymous, and if it is anonymous, and if a student or a junior-most scientist has given a complaint, we need to protect the whistleblower, because sometimes the research misconduct can be done by the senior-most scientist also. And before the proceeding, evidence need to be gathered. And the complaint or the complainant need to provide some evidence there is a plagiarism or a research misconduct. Once that complaint is lodged and the ICMR director or the RIO is clear that there is a research misconduct or plagiarism, within 15 days, a complaint will be sent and the respondent need to respond to the complaint. Based on the response by the respondent, the inquiry committee may be formed or dismissed. If the response is very clear and there is no research misconduct, the inquiry will stop. No, if there is a prima facie of evidence and the response is not adequate, the inquiry committee will be formed with 3 members, one being an external member. During the process of inquiry, confidentiality to be maintained because we are dealing with very sensitive issue. The inquiry should be completed within 3 months. And if there is a false complaint, even if it is anonymous, we need to find who has given the complaint and it needs to be dealt seriously. Further, after the completion of an inquiry, the director need to be informed about the outcome. And further, the inquiry committee will take the decision based upon the broader consensus of the majority vote. And the committee will suggest either there is no action will be taken because there is no research misconduct or plagiarism, or else they may issue a warning. They may suspend the research or suggest penalty or other actions. This is what the ICMR policy, my dear friends. Let's discuss about handling the misconduct allegation against researchers by the ICMR. Here is the flow chart, which clearly summarizes how the allegation of misconduct and how it is dealt. I have divided this whole flow chart into 2 parts. In the first, here in the flow chart, if there is a complaint given to the ICMR director or else to the head of the ICMR, immediately that complaint will be forwarded to research integrity officer. He will look into the allegation. He will see who is the complainant, whether the complainant wants to be anonymous. If he wants to be anonymous, then the whistleblower need to be protected. The complaint letter will be forwarded to the respondent, and the respondent has to respond within 15 days. And if the response is adequate, and if there is no research misconduct or plagiarism, that decision will be communicated to the director. If the response is not acceptable, if there is a research misconduct or else the plagiarism is there, that will be indicated or will be informed to the director or the head of the ICMR. Now, the head of the ICMR will do certain things. 1, if the response is acceptable, the publication green signal will be given to go ahead with the publication, and the researcher will be allowed to walk away or exonerated. If there is a research misconduct is there, or there is a doubt, an inquiry committee will be set up. One of the member will be an external member, and the 2 members will be internal. If there is a misconduct has been identified by this committee, they will look into the seriousness and the motivation of the misconduct of the research or the plagiarism. If it is a minor, a recommendation will be given for either by warning or withdrawal of the research. If it is a major misconduct or plagiarism, then the recommendation of penalty will be indicated by this committee, and that will be forwarded to the head of the ICMR. And the ICMR head will act according to the inquiry committee's report. Further, there is also a review of research documents and handling research misconduct before publication, dissemination at institutional level. That means this is to prevent the research misconduct and plagiarism. Here, the step-by-step process have been clearly said. If the headquarters where the ICMR is there, or else the ICMR research facility or affiliated to ICMR, if they have a ICMR or a plagiarism software is available, the publication document or the manuscript will be submitted to check for any kind of plagiarism and if there is any kind of research misconduct. If they do not have, they will contact the ICMR headquarters. The research integrity officer will facilitate plagiarism check. And if there is no plagiarism or else it is acceptable, that is less than 10%, that means the publication will be allowed to go ahead. If there are minor changes to be done, that will be recommended to the authors. Further, if there are minor changes is required, that will be done appropriately, and again, the manuscript will be checked. If it is a major, an inquiry committee review will be done. And if it is a minor, a warning will be given to the authors. And if it is a major, they will request not to submit the manuscript. And the final decision will be informed to the director. And those will be documented in the annual report. This is with regard to ICMR. Let's move into the DBT Statement on Research Misconduct. That is, Department of Biotechnology Statement. What they have said. They have also talked about and also formed a policy with regard to research misconduct. They are very clear. The DBT Statement of Policy with regard to research misconduct, they have said that organization shall take the responsibility of reporting, investigating, and sanction placement. That means DBT will provide the funds, will also look into the research, and also they say ICMR Ethics Committee approval has to be taken. And if there is a research misconduct, the organization where the research is conducted or the institution need to take responsibility of conducting the investigation and implementing sanction and reporting to the DBT. If that organization doesn't do anything, DBT can do an independent investigation if not satisfied by the organization what steps have been taken. Following sanction has been advocated by DBT. Withdrawal of the manuscript, stopping the funds for the research, and if the research has already been undertaken, the researchers will have to repay the funds along with the interest, and they also bar the researcher for doing further research. That means a severe sanctions have been advocated by Department of Biotechnology. Let's move into the University Grant Commission, that is UGC. As we know, UGC is under the special legislation, UGC Act. Further, University Grants Commission have come up with the regulation in 23rd July 2018. That is called as UGC Promotion of Academic Integrity and Prevention of Plagiarism in Higher Educational Institution Regulation of 2018. That means it has entered into a regulation. That means it is a legislation now. Here the regulations are very clear. It will be applied to all students, faculty, academicians, researcher, and staff working in all higher educational institutions in the country. In this regulation, plagiarism has been clearly defined. It says that plagiarism means the practice of taking someone else's work or idea and passing them as one's own. Here, there are two important points in this definition. One is stealing somebody's idea. Not only that, further, you're telling this work belongs to me. That means there are two important. There is a mens rea, stealing somebody's work, and also actus rea, by stealing, further you're telling this is my own work. That's what the plagiarism means. And also, this regulation is created with an objective of creating awareness with regard to research misconduct, plagiarism, providing training to the students and the staff to detect, prevent, and punish the person committing plagiarism. What are the advocation with regard to UGC with regard to research misconduct and plagiarism? Level 0. If the similarity index is 10%, that means minor changes, no penalty, go ahead with the publication. Level 1. If the similarities is around 10 to 40%, withdrawal of the manuscript. Level 2. Similarities between 40 to 60%. Following actions will be taken as per the UGC regulation. That means the researcher, the student, or the faculty of the UGC will be asked to withdraw the manuscript. They will be denied right to 1 annual increment. Further, you will be denied to supervise any master's, MPhil student, PhD student for a period of 2 years. If the similarity index is more than 60%, withdrawal of the manuscript, denied 2 successive annual increment. Further, you will be barred by supervising MSc or master's, MPhil, PhD student for a period of 3 years. These are the serious sanctions under the UGC regulation. Further, UGC not only talked about the plagiarism, it also talked about self-plagiarism, which was not there in the regulation. This notification came on 20th April 2020. It clearly said even self-plagiarism will be considered seriously. Let's look into this notification. What is the definition of self-plagiarism? That is, it talks about text recycling or self-plagiarism, republishing the same paper already published somewhere else and without citing that. That is one. Publishing smaller or accepted work from a longer and previous without due and full citation of the previous work. Further, reusing the data, already published work, or communicated for publication in another journal or another book without giving due and full citation. Breaking up the larger study into smaller and publishing in various journals without giving or informing about the citation or to the editorial board that part of the study is already published somewhere else. Paraphrasing one's own previously published work without and full citation of the original work. These are considered as self-plagiarism. And self-plagiarism will be taken seriously. They have clearly said that because of self-plagiarism, and if there is H-index, I-index of that researcher or the faculty, if it is high, that will not be taken into credit for promotion or for higher post. That has been clearly spelled out. Now, let's look into the law of the land, Copyright Act of 1957. Here, as per the Copyright Act of 1957, if you are the creator, you are the owner of that copyright, of that idea or the expressed idea in any form. Here, you have the right to give this to somebody else, or you can cite your own. And if you don't want to cite, that means it is not illegal, but it is considered as unethical, as per the Copyright Act of 1957. Let's look into the legal aspect of these copyrights. There is a Copyright Act of 1957, Patent Act with regard to innovation, models, especially for Design Acts of 2000, Trademark Act of 1999, Geographical Indication of Goods Act of 1999, Semiconductor Integrated Circuit Layout Design Act of 2000 with regard to motherboards or circuit designs. All these are under various departments or various ministry. Now, they are all under the Ministry of Commerce and Industry, under the Department for Promotion of Industry and Internal Trade. Protection of Plant Varieties and Farmers' Rights Act of 2001 comes under the Ministry of Agriculture and Farmer Welfare. Why I am saying all these things? If you look at the Copyright Act of 1957, it was earlier under the HRD ministry, but now it has been transferred to Ministry of Commerce and Industry so that it is under the single industry. Now let's look into the Copyright Act of 1957. The objective of this Copyright Act has been very clearly spelled out: the protection of the interest of a creator coupled with the dissemination of the knowledge. That means the Copyright Act balances between the rights of the creator and also the public interest at large. Here, in this legislation, they have clearly said that to plagiarize means stealing and passing of the idea or words of another's as own. That is plagiarism. It is a literary theft and can be taken as a fraud because it has two elements: stealing someone else's work and lying about it afterwards, telling that it belongs to me. So, plagiarism has been dealt seriously under this Copyright Act. As I mentioned earlier, this Act was passed in 1957 and came into force in 1958. Further, this Act has been amended 6 times: 1983, 84, 92, 94, 99, and 2012. 2012 was the major amendment which came into picture. And also there are copyright rules of 2013 and 2016. The office of the copyright is in Delhi. And ownership of copyright, that is, first owner, is defined differently in different categories of the product. There are 15 chapters under this legislation and 79 sections. These are the various chapters. Here, the chapter 1 is preliminary, 2 is about the Copyright Office and Copyright Board, 3 talks about copyright, 4 talks about ownership of copyright and rights of the owner. Terms of copyright is in chapter 5. Chapter 6 talks about license and copyright society in Chapter 7. Rights of broadcasting organization and performers in Chapter 8. 9 talks about international copyright. 10th chapter talks about registration of copyright. 11th with regard to infringement of copyrights. 12 civil remedies. 13 offenses. 14 talks about appeal, and 15 miscellaneous. Let's look into important aspect of this Copyright Act with regard to publication of books or scientific article. As I mentioned earlier, there are important statutory bodies in this legislation. Copyright Office, which is situated in New Delhi, and it has a registrar. Here, the registration of copyright of the various material is done. This is Copyright Office. Copyright Board, where complaints are taken, disputes are settled with regard to copyright. That is Copyright Board. Copyright Society is the association of the copyright holders. They grant copyright here. These are various administration with regard to Copyright Act. And this is the organogram. Ministry of Commerce and Industry, in the Department of Industrial Policy and Promotion, Copyright Office, Registrar of Copyright, Deputy Registrar of Copyright who will be looking to the aspect, section officer and examiners. What is copyright? As per this legislation, copyright is a right given by a law to the creator. The creators of literary, dramatic, musical and artistic work. Further, to producer of cinematography films and sound recording. Under this copyright, there is a bundle of rights given to the creator. Those rights of reproduction of the work, communication to the public, adaptation and translation of the work. There should be slight variation in the composition of the rights depending upon the work. That again a copyright permission has to be taken. Here, the copyright has important two aspects. One is moral rights and economic rights. Moral rights means the copyright, the creator will be cited anywhere, any place, and at any time. That is the moral. Economic right means by creating this, whatever the economic right is there, either he can take the remuneration completely, partly, or else he can transfer it to somebody else with regard to economics. Here, the rights which have been given under this copyright is, in case of literary work, copyright means exclusive right to reproduce the work, to issue the copies to the public at large, to perform the work in public, to communicate the work to the public, to make cinematography, film or sound recording in respect to the work, to make any translation of the work, or to make any adaptation of the work. That means with regard to publication of book or the scientific article, these are the rights for the creator or the authors. Copyright comes into existence as soon as the work is created. There is no need of formal registration. That means copyright occurs as soon as the author creates it. However, there are facilities available to register your work under the Register of Copyrights maintained in the Copyright Office of the Department of Education. Why should we register? If you register, it serves as a prima facie of evidence in the court of law. The Copyright Office has been set up to provide registration facilities to all types of works, and it is headed by the Registrar of Copyright, and it is there in New Delhi. Let's discuss about important aspect of infringement of copyright. Section 57 grants to the author of the literary work the special rights to be attributed for their work. It is the moral right and it's a perpetual in nature. As I mentioned, that means the creator needs to be acknowledged wherever it is cited. The statute recognizes the right to attribute analogous to the right not to be plagiarized. That means you need to cite. You need to give credit to the original author. That means right not to plagiarism comes under Section 57. Section 63 talks about infringement of this copyright as a criminal offense, and the punishment has been clearly talked about under the violation of Section 57, that is copyright infringement. The criminal offenses has been clearly dictated under section 63 to 69. Here, the punishment is up to 6 months to 3 years, depending upon the severity, motivation, and nature of the infringement. And the person who has done the copyright violation also need to do compensate with regard to money in terms of the act of infringement and what is the benefit he has got by that. Civil case also has been advocated under section 54 to 62. The remedies that can be awarded under this section is the injunction, that is to restrain further infringement, and also to restrain with regard to damages further, delivery of the account of profit. If somebody has done the infringement and he has got money, that money or the property need to be transferred to the original creator. Further, certain administrative action can be taken if he is in the government or else if he is in the private sphere where he is a public figure. Suppose if you are an author or a creator of a book or a scientific article, if it is violated or copyright violation is done, who will be held responsible? Is the author who has copied, or the authors, or is it a corresponding author or the first author? Is it the journal editor who is responsible, or the publisher? Who will be responsible? That will be discussed now. Here, one who is claiming the copyright of the work is liable for plagiarism. That means all the authors of the book or else the manuscript, maybe the corresponding author, first author, all authors will be considered for the violation of the copyright. Generally, the publisher has an exemption clause in the agreement which is taken by the author or the author has signed it. When the author signed the copyright form, they will this work is my own, they are original work, and I have not copied anywhere, I have not published anywhere else. That means the liability will be directly on the authors, not on the editors, not on the publishers. This copyright, as a general rule, lasts for 60 years. In case of original literary work, like dramatic, musical, or artistic work, 60-year period is counted from the year following the death of the author. Whereas with regard to literary, from the day of forming it. Let's look into the copyright forms, how it is there in the journal. Many of us, as a researcher, as a faculty, we have published in various journals. We have signed those forms. Without looking into it, let's look at one of the copyright form. If you look at the first one, it clearly says that I am the sole author of the manuscript. That means I am the manuscript owner and my colleagues or the co-authors are there. I am signing on behalf of those authors. And I have been signing because they have authorized to sign that, or else individual authors of the manuscript need to sign. That means they are declaring that is their original work and they are transferring their copyright to the publishers. And the editors need to check for this. And also, they are giving the publishing rights, that is, printing, publishing, and certain amount of economic rights, maybe partly or completely, to the publishers. If there are supplementing materials are there, that will be provided to the reviewers. And if there is a research data, can be scrutinized by the publishing company or by the editors. Further, the copyrights which have been given here will be solely for the economical purpose. The moral rights continue to exist with the authors. Further, if the article is published free of cost, it will be under the Creative Commons attribution, non-commercial, non-derivative work. That means it is freely can be distributed, it cannot be sold, but however, it cannot be tampered. Moral rights has to be kept high. That means you need to give due credit to the original authors. Further, if somebody is using it, they need to take permission from the authors. Further, if there is any changes to be done, permission need to be sought. Further, one need to remember this. And the author need to declare that they have not submitted any form to any journal when they are submitting to the publishers. Further, you need to look at the last paragraph. governing law and jurisdiction. The licensing agreement will be governed by and construed in accordance with the law of the country or the state of the journal owner or the publisher or the governing state, without regard to the conflict of law principle, and parties irrevocably consent to the exclusive jurisdiction of the court of the governing state. That means where the publisher or the journal owner is there, if there is any litigation is there in that country, in that place, the litigation will occur. That's what the signature of the author when he is doing and transferring the copyright to the journal. It can be partly a copyright will be transferred, or else exclusive rights, irrevocable rights can be given to the publishers. But however, how it is transferred? That is called as assignment of copyright under Section 18 of the Copyright Act. Under Section 18, the creator or the owner of the copyright, the author, can transfer or assign the copyright to another person, that is the publisher. Here, I am transferring my copyrights to the publisher to print, to distribute to the other people. The effect of assignment is that assignee becomes entitled to all the rights related to the copyright with regard to economic rights. Under Section 19, assignment of the copyright is valid only if it is in writing and signed by the assigner. That means the creator. If the period of assignment is not mentioned, by default, it is 5 years. That is very clear. But however, to keep the public interest at large, Section 52 comes into picture. There is a fine balance has been created under this copyright to balance between the rights of the creator versus the rights of the public interest at large. Too much of copyright control causes deterioration of the larger public interest. I can give you an example. If there is a COVID vaccine which has been done and it has been available now, and if complete copyright has been given to the creator, and the creator wants to sell and exploit the public at large, in such a scenario, Copyright Act Section 52 can exempt the copyright in the larger public interest. That means the creator may be the sole copyright owner. Exemption can be granted under Section 52. For the purpose of research or a private study, the exemption can be granted. For learning and teaching in the classroom, for the larger public interest, it can be given. If you want to criticize about the work or the literary work, it is allowed, it can be reviewed. For reporting for the current events, like so-and-so work has come in connection with the judicial proceedings, the copyright infringement cannot be applicable. For performance by an amateur club or society, if the performance is given in a non-paying audience, that exemption can be given. The making of sound recordings of literary or dramatic or musical work under certain conditions can be exempted under Section 52. Hence, under the Copyright Act, if you are a student and taking a copy of a book from a library, that can be exempted under Section 52. And for the purpose of research, you need to cite, but you need to quote it and you have to do it. That means you need to give the due credit. Further, if you are a teacher, you need to quote under this act. You need not pay royalty under this. That's what the Section 52 exemption has been granted under the Copyright Act. Here again, you need to understand the contract of services and contract for services. Contract of services means in certain countries, United States, Canada, and certain other countries, they hold the copyright for their employees. That means if I'm working for a United States government, and if I'm doing any work and there is a copyright involved in that, the US country will become the copyright owner. Similarly, if you are working for a newspaper agency and you have come up and publicized certain article, the owner will be the newspaper. That is called as contract of services. That means copyright is the employer, not the employee. But however, contract for services, here the copyright is the employee. You need to understand this. However, it depends upon the pre-agreement before the start of the work. If you are working for a company and by chance you are coming up with a product and you are the sole creator of it, what is the pre-agreement with regard to the employment? whether you will be the owner or else the employer is the owner. That if it is already predetermined before the starting of the work, the owner will be the creator or the employer as per the agreement. But please do remember, the moral right continues to be the creator. How to avoid the plagiarism? Please remember this, because if you are copying from somebody and the data world, it will become up very fast. And you need to avoid this plagiarism if you are a scientist, or else you are a student or a teacher or a researcher. And you need to do this because you need to keep the integrity at the topmost priority. Hence, when you are doing a research, writing a manuscript or a book, start early. Give time for writing and researching. Whenever you are researching, please cite them. Keep the references ready. And do not write or cite if you don't know who is the author. Keep track of your sources, from where you are quoting, from where you are citing. And cite while you write. And you need to cite the correct source. Don't quote somebody else. Use quotation marks when you are quoting from an author or a researcher. And you need to paraphrase it and cite it. Just because you are paraphrasing, you will not cite is completely wrong. It is again a plagiarism. And before you publish, please subject the manuscript for plagiarism software checker. Learn the English language because that plays an important role. And also you need to know there are many other languages where the researchers have done and published in various other languages. And you need to know about all this. But however, to make this job easy, there are various plagiarism softwares available. Let's review those plagiarism software. Let's discuss about free plagiarism software. Although I have mentioned 10 different free plagiarism applications here, they are not according to the hierarchy. I have not done the review. I have just mentioning these 10 different free plagiarism application. They're not completely free. Only part of the limited functionality has been given free, such as maybe 500 words you're allowed to check, or else one manuscript they're allowing you to check, or else they may not allow you to check the grammar mistakes. So they are highly limited in their functionality, or else they would not give complete permission to check their database, or else to withdraw the manuscript or delete the manuscript what you have submitted. You need to be very careful when you are submitting your manuscript to this free plagiarism software. Although they give complete privacy and also confidentiality with regard to manuscript, you have to be very careful. Whichever application or software is given free of cost, that means you are the product. Your product is manuscript. That can be misused. Hence, you have to be very careful when you are using free plagiarism applications. Although they are very good in certain applications and functionality, I would recommend you to buy a paid plagiarism software. If you buy them, that means they have obligations to provide services to you. These are the various paid plagiarism applications. One of the commonest which I use is Turnitin, and I have been using it for my publication. The second commonly which I use is Grammarly. Further, the DupliChecker, Pro Writing Aid, Viper, Plagiarism Checker X, Urkund, Plagiarism Detector Pro, Bybme, and Plagium. These are the various paid plagiarism applications. And these are, at this point of time, Turnitin, Grammarly, and Viper are being used across India, and these are paid. However, you need to know their functionality and whether it is you are publishing a book, either in the scientific community or in the literary community or in the arts, you need to know that. Hence, depending upon your functionality and the needs, you need to choose these paid plagiarism softwares. But there are certain points to be kept in mind. What is the cost? What is the annual subscription? What is the depth of the database? Whether the database is good with regard to scientific articles, or else research articles, or else with regard to arts, or else with regard to current publication. That means you need to know what is the depth. Whether these applications is for student or for the researcher or for the institution, subscription is allowed. And one thing you have to remember, whether if your manuscript is submitted to that application, whether your data will be safe, whether it will be out of control or it will be subjected to public, or whether the authors can delete if you had given the subscription, that means you should be the owner of the data. How is using this manuscript or the software should be there. And you need to have a side by side so that if you are comparing your original article and after checking whether it is yellow mark, blue mark, to compare side by side if that functionality is available, because that is one which is the most irritating part. After checking the plagiarism, you have to know what is your original manuscript and how you are changing it. If there is collaborating functionality, if there are multi-authored manuscript is written, and if you are able to share it by through this application to your co-authors, that will be wonderful. And if there is a browser extension available, it will be easy to do checking when you're using either in the Microsoft Word or any other application office you're using. These are the important points to be kept before you subscribe for the plagiarism software. To conclude, my dear friends, plagiarism is a very serious allegation, and you can be the victim or else you can be the accused for plagiarism. Hence, you need to be very careful when you're writing the manuscript. Just you have wrote the manuscript and you have submitted for publication is not the end of the world. There will be a publication. That means there may be a plagiarism, accidental plagiarism. You need to acknowledge all the ideas for the original creator. Hence, to protect the creator, the Government of India is planning to come with a strict law to prevent plagiarism in academics. And also, the law will consist of provision from warning to deregistration of students, dismissal of the teacher concerned. That is the seriousness what the Government of India is thinking. Plagiarism is both a legal and ethical issue. Though legal issue with regard to self-plagiarism is not there, but with regard to ethical issue, self-plagiarism is also considered an ethical violation. Hence, I request all the researchers and authors, be careful with regard to your publication. Please submit your manuscript to the plagiarism software to check what is the similarity index and learn the English language so that you can reword it, rephrase it. But however, you need to cite the original creator or the authors. That's it, my dear friend. Be careful about plagiarism. Thank you very much for giving your valuable time. Stay safe.